I will be your host for today. Hello and welcome, everyone. Welcome to our Family Law Now Live After Hours. Before we dive into today's topic, just a few quick housekeeping items I want to make note of. While we are here to provide valuable insights on separation, divorce, and family law, please remember that any information shared in this series should not be taken as legal advice. Today's topic is division of property of assets in Ontario divorce, and where we'll be covering various property division matters. If you have personal inquiries about your specific situation, we highly recommend reaching out to our office or consulting with a lawyer in your area to get tailored advice. And I will begin with our introductions. On top of your screen, you see our wonderful Steph. Steph has been with the firm since 2018. She was called to the Bar of Ontario in 2022 and is now an associate lawyer at the firm. Stephanie completed her undergraduate degree at Queen's University and obtained her law degree from the University of Liverpool in 2020, graduating with first-class honors. Steph, like everyone else you see on the screen, is trained as a collaborative practice lawyer, and she is committed to assisting clients through what is a traditionally difficult time by approaching matters with empathy, integrity, and compassion. We have Joseph on the screen. He's an articling student at the firm. He is set to be called to the Bar of Ontario in June 2024, a graduate of Ted Rogers School of Management at Toronto Metropolitan University, formerly Ryerson, and Queen's University Faculty of Law. As he enters the next phase of his legal career, Joe is committed to positively influencing the lives of those facing difficult family situations. Outside the office, he indulges in playing hockey and unwinding with comedy movies. Our top player. We have Russell here on the screen. He is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with the difficulties of separation and divorce. Russ has written 4 books and is a fully trained collaborative practice lawyer. He speaks at conferences on collaborative practice, marketing, technology, and the law. Lastly, there is me. I'm a law graduate from Osgoode Hall Law School. I'm an articling student at the firm with plans to be called to the bar in June 2024. I'm focused on launching my legal career in family law. I'm dedicated to providing empathetic and proficient legal support for those navigating family-related complexities. My experience stems from legal clinics and prior work as a legal assistant, and I'm poised to contribute to the firm's commitment to excellence in family law. Without further ado, I will jump right into our topic. Today we are talking about the property division regime in Ontario. This is often the most contentious and complicated part of a divorce. Depending on the type of assets you own, dealing with them can be very, very complicated. And Russ, you were talking about this earlier. The legal term for dividing property in Ontario is called equalization of net family property. And I will give it away to Steph to give us all an overview on how this property division regime works and what this casual term that we've been throwing around means.
Yeah, just, your everyday language of equalization and net family property is just, everyday chatter. But ultimately, when two spouses separate, we need to look at all of the wealth that was accumulated during the marriage, because this wealth is to be divided upon separation. So the key component, and every lawyer will tell you, financial disclosure is a must. We need to get your financial disclosure. We need to get your spouse's financial disclosure because it's going to outline all of the assets and debts that you had throughout the course of your marriage, from date of marriage to date of separation. So those 2 dates are going to be super, super important because what we do is we take a financial snapshot in time, looking at all of your assets, all of your debts on that date of marriage. And we do the same thing, a financial snapshot of your assets and debts on date of separation. So both you and your spouse would go through that process. And to provide sort of a number or a value on how much each spouse has grown or lost financially, we subtract, the debts from the assets, and then we also subtract the date of marriage values from the date of separation values. So mathematical terms to pretty much provide you with what we call your net family property value, or your NFP. So that's fancy terms of saying how much did you grow? How much did your spouse grow? And normally one spouse will have a higher net family property value than the other spouse. So, in order to share in the growth or to even the scales, the spouse with the higher net family property value would pay the spouse with the lower net family property value half the difference. So, the purpose or the reasoning behind this process is to allow for both spouses to walk away from the marriage on more equal financial footing. I will say this could be a topic all on its own, because there are always exceptions. There are always big things to keep in mind. One of the big things that we see is listing what we call excluded property, property that should be excluded from this formula, this calculation, because it's either an inheritance or a gift. Maybe something should be considered what we call a date of marriage deduction, something that you brought into the marriage that should be not included. However, one of the questions we always get is around the matrimonial home, especially if one spouse entered the marriage with that home or, is the only spouse listed on title. But the matrimonial home, we'll get into it a little bit more. I think Joe might jump in and soon, but the matrimonial home has special privileges. It has special rules around it because it is just that. It's a special asset. So the legislation provides those, exceptions around it. So that's broad strokes. That's quick and easy.
No, you're definitely right.
So what you're saying is you go into a restaurant, right, and you order cake. You want to share that cake equally, with some exceptions, right? Your assets is this cake, right? That's what your family assets are, and the percentage of the cake is what Steph's saying is your net your equalization share. But with some rules, we're going to talk about them. Gets complicated.
Definitely complicated. So one of the big special considerations, as Steph mentioned, is the matrimonial home. And really, this can also be in a segment in and of itself. But what happens with the matrimonial home in a separation or divorce is complex, but also cannot be complex, depends how you look at it. But first, it's important to note that when we speak of the matrimonial home, this piece of legislation, the Family Law Act, and when it's mentioning matrimonial home, it relates to spouses. And that means that the two parties are married. So this doesn't relate to common law relationships. It only relates to parties who have been married. And when we talk about the matrimonial home, we're referring to the main place where both spouses live together with or without a child after marriage and at the time of separation. So this could be a house, it could be an apartment, or even a vacation property like a chalet, as long as both spouses use the property regularly. And it's really important to note that there can be more than one matrimonial home at once. And it's also important to note that the residence doesn't necessarily have to be an owned property. It can also be a leased property. Now, the matrimonial home, as Steph said, holds special significance, not just physically, but psychologically as well. And that's why it does get the special treatment under the law. And specifically in section 18.1 of the Family Law Act, that's where it has the matrimonial home and its inclusions, exclusions, and special property and how it applies in that piece of legislation. Now, there's one important thing to understand, and that is that the value of the matrimonial home is considered fully shareable at the end of the relationship, unless there's a marriage contract stating otherwise, so also known as a prenuptial agreement. And this means that even if one spouse owned the home before marriage or even inherited it, its value is still up for division. So both spouses do have an equal right to possess the matrimonial home. That's key. And that's regardless of who's on title or who owns it. Neither spouse can sell or make significant changes to the matrimonial home without the other's consent. And when it comes to dividing the home's value, it's usually split evenly 50-50 between the spouses, regardless of ownership. So it doesn't matter if both people are on title or only one person. And because of the definitions outlined in sections 4.1 and sections 4.2 of the Family Law Act, the property's value, which is predominantly and usually the fair market value, is not excluded at the valuation date. So the valuation date is the day in which is known as like the date of separation. Nor can you deduct the mortgage, if there is one on the home, as a deduction as of the date of the marriage. And the court also can't force any spouse to buy the other ones out. And that's something that both parties will have to work in negotiations through themselves. So also it's important to mention that if one spouse does pass away, the surviving spouse usually has rights to the home, including the right to continue living there for a certain period of time, even if their name isn't on title. And after separation, both spouses are generally expected to share the fixed costs of owning the home. And fixed costs are predominantly the mortgage, property taxes, and insurance, property insurance of the home. And things get a little bit more tricky with utilities and other expenses that relate to the home. Usually, if one spouse isn't living there anymore and both are earning incomes, they're both still working and earning income, it might not necessarily be fair to expect them to cover expenses that they're not benefiting from. And that's pretty much the gist of what happens with the matrimonial home in a separation that leads to a divorce. And it definitely is a complex issue, but hopefully I gave you a clear picture of how it all works.
Really great comments about cottages, right? You wouldn't think a cottage is a home, and you might only be there a few weeks a year, but it can be. You can have more than one matrimonial home. I remember when I was in law school, one of the questions was whether can an RV be a matrimonial home, right? And if it's permanently affixed to the ground, apparently you can. So you really want to think about what's a matrimonial home and is it subject to division? But great points, Joseph. Thank you.
And I think we had this discussion amongst the lawyers in our office. How many matrimonial homes can you have, or what's the largest amount of matrimonial homes that's in case law? And I think we got 4. I think there was one case that the parties had 4 matrimonial homes, so it is possible to have more than one for sure.
That's a good problem to have, right?
Yeah, and the courts are very liberal with their interpretation of matrimonial home as well, because there's sometimes you may own your spouse may own a home, it's owned by the company that's controlled by one spouse, right? And then the courts will look through the corporate wheel, and if that's the 4th home, it's going to be the 4th matrimonial home. Okay, so great comments by everyone. I know we're just talking about assets that are listed in the net family property, and Steph, you mentioned earlier there are exceptions and assets that are not included. So let me take a few minutes and talk about those assets that are that can be excluded from net family property. So first up, we have a property that was received as a gift or inheritance after the marriage date. This is excluded. I emphasize marriage date because gifts and inheritances acquired before the date of marriage are included in your net family property value. It is only the pre-marriage value that is deducted from the net family property, just like any other asset. Steph explained it beautifully. The same applies to gifts and inheritances if they are received before marriage. The exception is gift or inheritances received after the marriage. If you received it before, the increase in value will be shared. If the gift or inheritance forms the matrimonial home, the exception does not apply. Joe mentioned Mad Home has a special status. I believe next week we are talking about the matrimonial home. Correct me if I'm wrong. So we'll cover it in more details then. But the whole idea is if the gift or inheritance becomes the matrimonial home, or if your gift or inheritance can be traced into the matrimonial home, then you lose the exception. And I said traced, and by tracing, I mean the gift or the inheritance was used toward the matrimonial home. It could be to buy it, to renovate it, pay down mortgage. Once you commingle it with the matrimonial home, then that's it. It's part of your NFP now. An example for this could be you receive a car as a gift after the date of marriage, and you sell that car, and the proceeds of the sale go towards making a mortgage payment. And you have essentially lost your ability to exclude that car. Tracing also applies outside matrimonial home context. If you receive a gift and you sell it to buy something else, if you can trace that money back to the gift, let's say you bought a bed, then you can still exclude it. Tracing can get really complicated. It's good to speak to a lawyer if you can. Also, income from gifts and inheritances that can also be excluded from the net family property as long as it's explicitly stated that it is to be excluded. Other things that are excluded are financial damages from a personal injury claim. If you get into a car accident, for example, and the insurance company pays you 30K for personal injuries, that amount is going to be excluded. Life insurance proceeds, when a spouse holds a life insurance policy, the proceeds from the policy are payable to the beneficiaries upon their death. This value is excluded. Lastly, anything that the spouses mutually decide to exclude as part of their marriage contract, prenup, that will be deducted from the net family property calculation. There's freedom of contract and room to add to that contract. That is pretty much all the exceptions. Anyone wants to add anything here? Going on? Okay, no. I believe now we have covered, because I want
Well,
to.
we're gonna add more next week, right?
Oh yes, we
Like
should.
we got
Yeah,
a lot to cover off.
we got a lot
here.
to cover for next week.
That matrimonial home's complicated. It's got a special section in the Family Law Act, special rules. You want to make sure you follow it. You know, certain fact scenarios could really affect the outcome. So if you own a matrimonial home, you own a home, you bring it into the relationship. At the end of your relationship, you're married, still the same home, you lose the deduction, it's shared. That's what the rules say. If you own that same home, brought it into the relationship, sold it, bought a new home, the new home's a matrimonial home, you got an argument to say my first home qualifies for date of marriage deduction. The value of homes these days is a $700,000 million swing. You want to make sure you get it right. So talk
And
to a
that-
lawyer.
That's why we said, the matrimonial home and property division in and of itself is always so contentious, because a
Right.
matrimonial home is often the greatest asset in any relationship. So that's usually where, the dollars really make sense. And it's important to get tailored legal advice to know that, those dollars and those heavy amounts are being treated appropriately.
Yeah. Just on that note, we had a question come in and somebody got signed off with a notary on their separation agreement. Is it enforceable? Well, look at what we're talking about here. Notary's not making sure disclosure is complete, the appraisals are done, whether or not it qualifies as a matrimonial home, is if there's duress, is there independent legal advice? If the result's unfair and inconsistent with the Family Law Act, the judge will probably say, we're not going to follow this agreement. So what I'm trying to say to our audience is, be careful of this internet stuff, kitchen table agreements, cut and pasting an agreement your friend got done. Might not be worth the paper it's written on, and you may end up having 2 years of litigation in court arguing over whether it's valid. Take the time, do it right at the front end, would be my take. What do you think, Steph? You've seen these quite a bit now.
100%. And, people coming back, I know we spoke about spousal support last week, but that's a big one. A spousal support release done through a kitchen table agreement, 4 years, 5 years down the line, the court says, I'm sorry, but that agreement, it's not valid. You didn't have disclosure. You didn't have independent legal advice. That agreement's now being set aside. So issues that you thought you settled could resurface and come back up, and property is a big one. And especially if you're having to go back in disclosure to look at a value of an asset or a value of a debt, if you had a 20-year long marriage, it can be extremely time consuming. So doing it properly and doing it right the first time is extremely important.
And we're getting great questions coming in from our audience that tells us you're tuned in, you're paying attention, please keep sending them in. We'll try to get through as many as we can, but lots to cover off. Great point, Steph. I agree with you.
Thank you, Russ, and thank you, Steph as well, and Joe. I believe now we have covered everything in terms of what kind of assets form part of your net family property. Russ, I would love it if you can go more into how all of these different assets, property, business, pensions, how are they valued?
How come I get all the easy questions? My God, what are you guys doing? All right. So what I'm talking about. All right. depends on the nature of the asset, first of all, right? If it's some junk that you have in your house, you got the couch you bought from the brick 10 years ago with the stain on it, it's, whatever somebody's going to pay for that couch, a couple $100 at an auction or garage sale, you're not going to get the $2,000 you paid for the couch. So most of the assets are market value at auction, or something similar to that. Ideally, you're going to agree on the value of these assets and divide them up amongst yourselves. Judges tell us all the time they're not going to do pots and pans. They're not going to divide up the stuff. It's too expensive. Figure it out, right? The court doesn't have the resources to do that. Pensions have their own special rules. We have legislation in Ontario that deals with pension. You fill out specific forms that are legislated. You send it to the pension administrator. You pay your fee. If you do the forms correctly, you probably get a report 4 to 6 weeks later that tells you the language we use is the family law value of that pension. All right, this is the amount you can share. So lots of people are working prior to marriage, and that portion that they acquired is deducted from the valuation. Or they continue at the same company after they separate. So post-separation increases is not included. The family law value is date of marriage to date of separation, valuation date. We're going to talk about that. Businesses. Again, we've got Saving the Golden Goose series. You can find us online, send us an email, we'll send it to you. Specifically designed for family-run businesses. What kind of business are we talking about? If it's a publicly traded company, that's easy, right? The market's going to tell us what the stock value is. Privately held family businesses, much more complicated. It depends on the size of the business. You may want to look at the tax returns, you may want to look at the financial statements. You may want to get a certified business valuator to do a look at the books and give you an oral report. You may want a written report, which is going to be more complicated and more expensive. You may want a forensic audit if you suspect there's some mischief going on. Take a closer look at the books. Again, more expensive, right? So you want to be mindful. What's this asset worth and how much are we going to spend valuing it? So if one of the spouses is a trade person, say a plumber or electrician, and they got a van full of tools, no inventory. They are the business, right? If they weren't working, there'd be no business. You're not going to spend $40,000 valuing this business, right? The van and the tools might not even be worth $40,000. So what's the nature of the business? Your lawyer would have a pretty good idea in terms of what degree of due diligence do you want to do? Do you want to bring experts in? Here's an example. Let's talk about real estate, right? You've got this home. You can agree on what the value is. You know what your neighbor's house sold for down the street. They've got a pool. You don't got the pool. You get a flavor as to where the market's going, right? Next step up would be maybe call the real estate agent who sold you the home, get an opinion of value from the couple of agents. So that's kind of loosey-goosey there, right? They may come back high because they want the listing, or they might come back low because maybe it's not an arm's length real estate agent. Maybe they're siding with one party and they want to buy out the home. So you want to be mindful of that. Or you can get a certified appraisal. This is what the banks get when they're giving you a mortgage, right? They got an expert come in, look at comparables, provide a report, which is usually fairly accurate depending on market conditions. 2 years ago, nothing was accurate, right? We had bidding wars, cash bidded for homes. Like nobody could predict what's going to sell for. $100,000 over asking, who knows? So these are all different levels of steps you can take to appraise the asset. The ultimate test is the market, right? Sell it on the open market. That's going to tell you what that asset's worth. So if there's a dispute, or you want to you're entitled to test the market too, and see what the market will bring. Who knows what's going on with the market and interest rates these days? So again, we've got programs that talk about valuing assets. This is just a flavor. Depending on the asset, how much work you want to spend it. The greater the asset, the more diligence you want, right? You want to understand the capitalization of the corporation, tax consequences, how much money we can pull out if it's a multi-million-dollar company. If it's a tradesperson with tools and limited client base, you're not going to go to that length. So that's sort of, those are the goalposts, and then there's everything in between.
Thank you, Russ. That was very insightful. There is so much that goes into determining the value. And like I said earlier, it's very complicated. I think sometimes you have to even bring in experts. There's different variables and different types of interest that makes it really tough. And now I'm talking about stocks, investments, trust. And I know we also have a couple of questions asking about stocks here, Russ. So
Yeah.
I will bring you back on. Can you talk about more complex assets here?
All right. Again, what's the nature of the asset? If this is a publicly traded stock, we could figure it out, right? We can go back historically, find out what it's trading at on your data separation. Lots of litigation over post-separation values, jumps in assets that, in my view, goes nowhere, right? Data separation was key. And I'm going to tell a story because I love the story. The audience loves the stories, right? So I had this case. I had the husband, and the data separation value put his interest in the company, I don't know, 700,000, something like that. Post separation, they landed a new contract and it went to $10 million. Naturally, the wife thought, what the hell is going on here? You delayed signing that contract until after we were separated because now I'm short, right? The assets swung by $9 million and change. And I would be suspicious too, right? So we had to take a close look at how this contract was executed and the timing of the negotiation. And we had directors of this company that didn't want to participate in the court proceeding, right? And so we needed an order from the judge for third-party questioning to find out exactly what happened. And apparently it was all legit. The stocks jumped after separation and the number was correct. But again, it depends on the asset. So privately held companies can be much more complicated. Pensions, we talked about, investments. Look at crypto, right? Crypto's up 120% last few days. Insane, right? These assets are all over the market. 2 years ago, crypto crashed. People were losing their shirt. Companies were going bankrupt. Huge fluctuations in these assets. So you want to be really mindful of the timing of these assets and whether they're jumping or shrinking. We're seeing that with the real estate market as well. As recently as 2-3 years ago, we're seeing some stabilization there. International properties, another complicated beast, another story. Don't want to take everybody's time up, but we had a family who had property in Spain. And it was subject to division because it was an asset of the marriage. However, we can agree on the value of the property in Spain, different language, different time zone, hard to get experts local to that specific region. And you got to remember the Ontario court doesn't have jurisdiction to deal with this property, right? So we cannot make orders for the sale of this property in Spain. So this is complicated as well. How are we going to value this assets when the parties don't agree? We're dealing with a foreign country, different language. That case, we ended up retaining counsel in Spain to assist with getting an assessment of how much this asset was worth. Somebody was going to take it over and we're going to set it off against other assets here in Ontario. So you want to be mindful of the nature of the asset, whether you can get some public data on it's being traded, whether you're going to need expert evidence to evaluate it, whether you need third-party court's order, third-party disclosure to help you assist with the valuation. You want to be mindful of where's the asset located? Is it in Canada? Can the Ontario court deal with this asset? Or is it international, or we're going to need the assistance of a foreign court or foreign lawyers? So lots to think about. Then again, you want to be mindful. What is the asset? How much are we talking about? If it's an RV that's used parked in the United States, that's a different nature than, a multi-million-dollar property in Spain. You can spend more money getting the correct number on the property in Spain, because if you spend it chasing the RV in the US, you're probably going to spend more in legal fees than you're going to recover. So you want to be kind of practical when you're doing all this as well.
Sure, and so much goes into stocks, especially. Like I know there was a question regarding stocks acquired and that they weren't exercised. There's one case, even when there's stocks that have been vested or unvested, and it's how do we get a value for the unvested stocks, and it really comes down to getting an actuary involved, getting those numbers down, especially if you want to get a date of marriage deduction on the stocks. So it's really, really important to hone in there and get those values.
Stock options, when can you exercise the option? Yeah, you're right. And those options might not be available. Sometimes the person needs to keep working at that company for a period of time before they're going to realize that option. So great point, Joseph.
Yeah, for sure. Good points, Joe and Russ. We love picking your brains, Russ. Thank you for this overview. I know we have covered assets in some detail and we're halfway through as well. So let me take a few minutes to talk about how is debt divided. So equalization section 5 applies to married couples. If you're not married, if you're common law, then your debt is your debt. Your spouse's debt is their debt. You're only responsible for debt that is under your name. Debts that are jointly held, like a mortgage, a joint line of credit, or joint credit card, that is something that is divided. Now, on the other hand, if you're married and you're in the equalization room, for equalization purposes, you subtract debts from assets when you calculate your net family property. That's the math you're doing. So any debt that's incurred during the marriage by your spouse, that is something that gets deducted from their assets for equalization. This doesn't necessarily mean that you have to pay half of it, but the debt does factor into the calculation. It affects the equalization payment, it affects you. So let's say one of you is debt free and the other person has 50K in debt. It factors into the overall property split. So you aren't off the hook under Ontario family law just because your name isn't on that loan. But there is a provision under section 5, and it says that if somebody improvidently depletes their assets or incurs a debts that are incurred recklessly or in bad faith, something that is completely unreasonable, nothing to do with the family expenses or lifestyle, an expense, maybe a vacation out of the blue, a very expensive one, incurring huge gambling debts. That is something you can have recourse for. So that's my little 2 cents on debt. You know what else impacts the calculation of family property? Date of separation, and Joe will speak on that next.
Yes, the good old data separation. It's extremely important in determining asset value in division, and it's often a date that is disputed by parties. And there's so much that goes into why the data separation holds such immense importance in determining asset value in division. Under Section 4.1 of the Family Law Act, the valuation date is defined as the earliest of several potential dates. I believe there's 5 or 6 dates listed off, but primarily it's marked by the date that spouses separate with no reasonable prospect of resuming cohabitation or reconciling the relationship. Now, it's really crucial to note that separation doesn't necessarily mean physically living apart. This is a definition that we've discussed in past videos that we've taken apart in, but you still can be considered separated even if you're still residing in the same house, as long as there's no intention of reconciling. However, being able to substantiate this can sometimes pose a challenge, and oftentimes it requires concrete evidence, especially if you are disputing the date of separation. But the big question is, why does the valuation date matter, especially when it comes to asset values that are fluctuating or new assets that are involved in the relationship, for example, like stocks or even a lottery win? Well, the purpose of the date of separation and the valuation date ensures fairness in the division process in and of itself. And by establishing a clear valuation date, it basically guarantees that both parties are treated equitably and that it accounts for any changes in value, asset values over time. So any assets or debts that have been accumulated after the date of separation are solely that of the person whose name it is associated with respect to the collection of the asset or the incursion of the debt. And therefore, it does not really come into play in determining the net family property during the course of the marriage. Because as we spoke about earlier, net family property is from date of marriage to date of separation. So anything outside those goalposts is not inclusive. And in essence, the date of separation isn't just merely a technicality. Rather, it is a fundamental aspect of ensuring fairness and equity in asset division. And it provides clarity, provides transparency, and that ultimately allows lawyers and the courts in and of itself to lead a more equitable division resolution for both parties. Thoughts, concerns?
Thank you, Joe. These are great points. Russ, were you going to say something? Sorry, go ahead.
I'm just trying to go through some of the questions. We're getting some fantastic questions coming in. Please keep them coming. We're going to try to get through as many as we can, but yeah, that's a great summary, Joseph. Thank you.
All of this speaks into the valuation issues. Date of separation, like you just mentioned, Joe, is not just about when you separate. It's a reference point, and it can have a significant impact on your property division. This is why we say, please get tailored legal advice, get a separation agreement. Separation agreements is how you can enforce your rights. Whatever property division arrangement you and your ex-spouse settle on, have an agreement signed on it. If you are going to court and if you can't agree on an agreement, the court will equalize your family property, and that will be in accordance with the Family Law Act, what we've been talking about today. If you have entered into any agreements that specify any property that should be excluded, that property will be excluded. Other than that, generally the court does not have discretion to deviate from the property equalization regime. But there is no obligation for you and your spouse to go to court or to divide your family property as it would be divided under the Family Law Act. You are free to decide on the division as you choose, and then you formalize it with an agreement. Seek legal advice before finalizing any property sharing agreement, particularly if the marriage has been a lengthy one and you have built up assets during that time. At the end of the day, you should want to know what you're entitled to. And if you do want to enter into an agreement that's different to what you've been entitled to, there's nothing wrong with that. But you want to make sure that you make an informed decision. And let's say you can't agree and you don't want to go to court either, then there are dispute resolution options available. Joe, would you like to speak on those?
I realized I was muted. Yeah, so everyone on the screen, we all are collaboratively trained professionals. So what that means is that we do work outside the confines of the traditional legal system, the adversarial legal system, and we work with one another, with opposing counsel who are also collaboratively trained, as well as other family professionals to help come to a resolution. There are also other dispute resolution options, such as mediation and arbitration, that are often useful for property disputes. Beginning first with mediation. Mediation is facilitated negotiation process that also has a neutral mediator, so they don't pick sides, they're neutral, and parties work together to reach a mutually agreeable solution. With respects to mediation, it's non-binding, but it does lead to voluntary settlements between the parties. With respects to arbitration, arbitration is a more formal process where an arbiter makes a binding decision. That binding decision is legally enforceable. And within arbitration, parties present their cases and their evidence, and it's very similar to a court setting, except you're not actually in court, you're with an arbitrator rather than a judge. Both options offer alternatives to costly and time-consuming court proceedings. They provide flexibility and also privacy in resolving property disputes because, as many of you do or do not know, when you go to court, those documents are made public. However, if you are in mediation or arbitration, all of that does stay private. And what's really good about mediation and arbitration is that it does help avoid prolonged litigation, and it allows you, the parties, to maintain control over the outcome. We've always said, going back to the previous shows we've hosted, that no one wants a third party like a judge with the information they have presented in front of them to make a decision about your lives. So obviously the best outcome is to work with a lawyer who's even collaboratively trained to come to a solution that's tailored to your specific situation, as opposed to having to go through the legal system. It also should be noted and heavily emphasized that the law is fairly settled on these issues with respect to property division, and that it really is important to trust your lawyer's advice. Oftentimes, what they're telling you is not because they don't want you to succeed in your case, but it is the fact that it is the law. It has been settled through case law, and we're here to provide you the truth. We're not here to babysit you. We're here to tell you as it is, because telling you the right advice up front is what's going to allow you to settle your matter in a cost-effective manner, and at the same time it can also be the best possible outcome in your case.
Great points, Joe. And I was just going through the questions, and I know we're talking about like negotiating a separation agreement, going through a DRO. I know like there's a question that says there has been delays in agreeing to equalization. So I do want to like bring it to light here that there are limitation periods, and there is a 6-year limitation period for equalization as well. So just to put that out there, you don't want to delay too long. And if you cannot reach an agreement, speak to a lawyer, and they can help with that. Moving on, I am hoping
And
staff.
parties can either agree to extend, or a court can extend a limitation period. You want to negotiate a settlement, and if both parties are making progress, you may want to ask the court to extend a limitation period. But if somebody's up to some mischief, right, they're sitting on their hands hoping a limitation period will run out, want to be careful about that, and make sure that you don't miss, because you don't want to have to spend the money to go to court to now extend a limitation period that's expired. Go early, put everybody on notice, and seek assistance if necessary. So very great tip there, Shanza.
Great point, Russ. And there is one more topic, and I'm hoping, Steph, you can speak a little bit on it before we open the floor for questions. And that is how asset value may change after separation or divorce. Can you talk about understanding these changes?
Yeah, of course. One of the trickier parts of the transition from being a married couple, to living two financially independent lives is, those post separation expenses and those adjustments that have to be made to ensure that each party pays their fair share until whether an agreement is reached or the divorce is finalized. So, in the midst of the separation process, emotions are running high, finances are still very much entangled. People don't always like to find out that they're playing by new rules. So the data separation is going to be that key moment. I know we've mentioned data separation a lot, but it is very, very important. So that period of time is going to be key in, moving forward, how finances are divided between two spouses, or how shared expenses are going to be divided. So in general, I tell clients that both spouses should expect to share the fixed costs with owning the matrimonial home, regardless of whether they live on the property, because it is a joint asset. So typically those fixed expenses are the mortgage, the property taxes, home insurance, and those are split 50-50 post-separation, in recognition that provincial law ensures that each married spouse has a 50% interest in the home. Of course, there are exceptions, but that's, just the general rule. But things really do get trickier when it comes to utilities and more discretionary expenses. If one
like the Netflix account.
Yeah, the Netflix account, utilities, who pays for the dog food if there's a dog. So usually,
right, it's a consumable, right? Like, the internet. Well, you're using the internet, I'm not, right?
Yeah, exactly. So if one spouse, for example, is still living in the matrimonial home, and the other spouse is not, and they're not benefiting from the water, the internet, the Netflix, the dog food, the dog to have the dog food. I hope you're not eating dog food, but if that's your choice, that's your choice.
We did get a question about the BC pet case legislation.
We did. I'll circle back to that 100%. But yeah, traditionally it's well, it's arguably unfair to expect a spouse that's not living in the home or not benefiting from those costs to be paying for them. So the allocation of other expenses to one spouse or another may be straightforward, but practical issues can result in an adjustment. So one spouse may not initially notice that their partner's car insurance is automatically being taken out of their account, or loan payments you may be overpaid or paid something on your spouse's behalf post separation that you need to adjust for. So, another common one we see a lot is one spouse used a significant amount up on a joint line of credit for personal reasons, or took more than their share of funds from a joint account. So, all of those things that can happen during the negotiation process or during the process of finalizing your separation or divorce. It's important to bear in mind that those adjustments can happen, and to speak to a lawyer to get the disclosure to ensure that everyone's paying their share and what they should be contributing to. And
Yeah.
I'll just add one more thing,
Mhm.
that I've noticed judges, they're really not interested in getting into the weeds of who
Mhm.
paid what bills, especially if more important issues are at hand, like parenting or support. But the court will not look very fondly on if a spouse racks up a significant debt, a significant joint debt. There was a case. The name of it's escaping me, but we'll include it in the show notes, where one spouse was incurring a significant debt due to financial irresponsibility, and that debt was attached to the matrimonial home. So in situations like that, where one spouse isn't playing fair, the courts can award an unequal division of family property to sort of rebalance those scales, if the equal division would be unconscionable given the circumstances. So it is important. Play nice, don't play dirty, because it's not going to get you anywhere in the long run.
Maintain the status quo, right? Steph?
Maintaining the status quo 100%.
Now, this is such an important topic, and we get it a lot. And I just want to touch upon that. That was great, Steph. And we've gotten a lot of questions tonight about occupation rent. And this is a tough topic, right? So, what the hell's occupation rent? Well, you're in the home. I'm not. You're occupying my share of the home, right? My capital is being tied up right now. So since you're occupying the whole home, you should pay me rent. That home's going to rent for $4,000 a month. So my 1/2 share should be $2,000 a month. You've been in there for 24 months, let's say. So now you owe me $48,000 in occupational rent. It's a notional cost, right? Nothing happened. There was no agreement. The numbers can be significant if the case doesn't settle right away, or if the home would rent for more than that, right? Maybe the home rents for $10,000 a month or $20,000. It's a tough standard, though, right? If you look at the case law, basically the spouse needs to be excluded from the property and can't access it. So maybe you got an order for exclusive possession. What if there was a criminal charge and the spouse was removed from the home? Now that person's excluded because of his own or her own criminal conduct. That's another set of factors, right? Generally speaking, I see lots of people make claims and plead occupation rent without understanding what it means, and it's a tough standard. And I don't think case management judges are going to willy-nilly say, yeah, we're going to give you $50,000 in occupation rent. It's very fact-driven, so you want to talk to a lawyer about that. The other issue that you kind of touched upon, Steph, which is kind of interesting, right? We're talking about property tonight, but lots of times support issues blend into property issues, right? So maybe hypothetically, one spouse is in the home, the other spouse is out, but is maintaining the mortgage payment. But that spouse may have had a support payment that should have been due as well. And so now that's the first spouse who's in the home says, I want retroactive spousal support to the date of separation. Well, that may not be fair because the other spouse was paying the mortgage and should get a credit for that, right? They're not enjoying the home. So that's where you see support and property issues kind of blend into each other. Steph talked about this a little bit, line of credit, credit cards, right? You want to look at, with somebody cranking up the debt, knowing they're going to separate, pulling that asset, moving the line of credit and buying crypto or moving it into cash and hiding it. Or is it a post-separation adjustment, right? So we're no longer talking about division of property. We've got the date of separation credit card balance, but maybe there was a withdrawal after the date of separation that needs to be adjusted for because it's a joint debt and both spouses are still on the hook to the bank to get that cleared up. The only other thing I want to say about this, because it's important, and we see this unfortunately a lot, some spouses play games with credit cards and lines of credit. They cut off the credit. They cut off the secondary credit cards as a litigation strategy, right? So that their former spouse can't hire a lawyer, can't pay their bills, or may make a bad deal because they don't have any money. Courts generally really frown upon that conduct and will likely order costs if, like Steph, like we're just saying, if you're not maintaining the status quo until there's a new agreement in place or a new court order, and you're being reckless with managing this credit to the deprivation of one spouse, it may seem like a good idea at the time, but when it goes before the court and the judge gets wind of it, things are going to go badly for you quickly. So you want to be, like Steph said, play nice in the sandbox, come to an agreement on these issues as much as you can, and live by the interim agreement. Even things like canceling insurance, life insurance, or health benefits, all these should be maintained. Car insurance, people are canceling car insurance. It's crazy, right? You want to maintain this until there's a new agreement in place. But great point, Steph. Thank you so much.
No, thank you, Russ, and Steph, both of you. Those were some great points. And thank you, Russ, for slipping in support and occupation one in there. We have so many questions come in about these topics. And I think overall we had a very productive session today. So let's slip in a question or two in here. I know there's one that just came in about mediation and challenging a mediation award. Joe, I know you were talking about it. Do you want to take a moment to answer this one?
Yeah, sure. So with respects to mediation, any conversations that go on in mediation, we said before, are non-binding, and the decisions that the parties get are non-binding unless there is an agreement that's been signed by the parties. So if there's been communication, both parties seem to be on the same page, and you leave mediation but nothing's signed, you can't rely on what was agreed to verbally. So you really have to make sure that if you are coming to an agreement in mediation, in order for that to be considered binding, there has to be a signed agreement. If there's no signed agreement, then it's like nothing ever happened. So it's really, really important.
Awesome, thank you. And I have one more question, and this is a roundtable question for all of us here, because I think it's
Roundtable, this is exciting.
What if my spouse is hiding assets or undervaluing their property?
Mm-hmm.
What do we
Is
do?
that a question?
That's the
Or a
question.
statement? I think that you're asking, what do I do if that's happening?
Yes, the question is, I believe they are worried that this is happening. And
Right.
so if this is something that a person may be doing, hiding their assets or undervaluing their property, what is something that can be done to avoid that?
I think the host should go first. What do you think, Steph? Shanza, you take the first kick at it?
It's roundtable. I don't know. Anyone can
Yeah,
jump
let's start the round table with the host.
I jinxed myself by throwing it as a roundtable question, but but for sure, I think if your spouse is hiding or undervaluing assets, I know I keep saying this, but it's best to involve a lawyer. Lawyers can uncover and catch information. It can simply be done by examining the documentation sometimes and knowing where to look, reviewing the tax returns, banking records, look at their lifestyle and their income. Like, how are they living sustainably for someone who makes their amount of income? right? And if it's something more complicated, we can involve professionals. They can do a more thorough examination of assets and liabilities. But I think like sometimes just having a lawyer um force the truth out, it could be as simple as that. But yeah, I'll leave it to the rest of you to maybe add some more on here.
Yeah, and I
Yeah,
think
let's do reverse seniority. Let's see what Joseph thinks, and then
oh,
we're gonna bring our senior lawyer stuff in here to clean up.
Yeah, for sure. So, typically when negotiations between counsel begin, at least I see what it's to be as common practice. There is a form, what's called a financial form 13 or form 13.1, and that's a document that's used by the courts, and that's what allows people to list their financial statements. And these documents are sworn, they're affidavit sworn. So, if you lie, you get in big trouble. So you have to tell the truth. So oftentimes lawyers do rely on those statements. So the general rule is that one, that you don't lie on these statements, and as because they're relied as evidence in court proceedings and in negotiation. So that's definitely the first area that you would want to go to in terms of A, did this person lie on this affidavit? So that's also really important. And two, in terms of undervaluing someone's property, a lot of things are very hard to undervalue. In terms of property such as homes, those things can easily be like the fair market value can be generated from appraisers or even real estate agents, with cars and other types of vehicles, the blue book. So it is tough in that sense. Um, Obviously, there's other ways and other means of getting those values. Even or if people you believe they're hiding assets. Sometimes we do employ private investigators. However, though, it's not necessarily the norm. But in and of itself, it's really important to be truthful with your spouse when you're negotiating because that sets the stage. And like Shanza said, if a judge finds out that you've lied or that you weren't truthful on your sworn financial statements, there can be serious consequences associated with that.
Stuff. What do you think?
yeah, and just
Serious
jumping on.
consequences.
There are, and
Yeah.
actually in legislation, it does state if either party has lied with, has not disclosed a major asset or a major liability at the time a domestic contract, so a separation agreement, was entered into, a court can set it aside. So you might lie now, but it's going to come and bite you in the behind later. So it's always important to provide full, transparent, accurate financial disclosure. Also, just providing disclosure in and of itself, we see people saying, well, I know what they have, they know what I have, why do I need to exchange financial disclosure? But again, turning to legislation, if you don't disclose it, you don't understand what you're entering into, you don't understand what you're entitled to, that agreement, it cracks holes in the foundation of that agreement. One thing I'll sort of point out or restate, that Russ mentioned earlier is you need to weigh the cost benefit analysis, right? If you're going to spend hundreds, thousands of dollars on private investigators or experts because you think your spouse undervalued a ring or might be hiding an extra savings account, how much do you really want to pay somebody else to uncover maybe a couple $1,000s? So it's important to have those discussions with your lawyers and to really take their advice and their recommendations to heart because they're just looking out for your best interest. Russ, anything else?
First of all, I want to thank our audience. This has been probably one of our most interactive audiences with great questions. We're trying to answer as many as we can. You found tonight's show valuable and you have a friend or family going through separation and divorce, bring them to our series. We're running this every week. But yeah, I do have some things to say. There's a veteran in the audience who asked a question about pain and suffering awards. First of all, thank you for your service. Personal injury rewards are complicated. Pain and suffering is generally excluded. However, there's usually income replacement components to these. So when I get them, I want to get a report from the personal injury lawyer or the lawyer who helped you with Veterans Affairs and ask him or her to give me a breakdown of the award and what's income, what's pain and suffering. Because sometimes you get a lump sum, but it represents different things. So, and the same goes with personal, car accidents, industrial accidents, any kind of injury award, and you're off on, you're getting compensated for income and suffering. You want to look into that. But that goes to income, but it could also go to an asset as well. This brings in this blended, support property issue that we brought up earlier. Steph had a great point about disclosure. If you're up to mischief and you've lied on your financial statement or your disclosure, you're going to lose credibility with the court. Judge isn't going to accept anything you say. That's it. Any doubt is going to be resolved in your spouse's favor, and there'll be cost consequences. Shanza hit the nail on the head. What's the lifestyle? Lots of my clients have cash in boxes and in safes. It's surprisingly common. This end of the world thing, gold bars, silver bars, right? So if you're concerned, take a picture, take an inventory of the safe, get some documented before it's gone or before it moves. You want to look at the history of the marriage, right? Or maybe you paid for your holidays with cash, and this has been going on for 20 years. And this is evidence you can bring into play. You can tell another story because it's after hours. We had a case, car dealership, and I had the wife. Really complicated fact scenario, but long story short, she was certain husband's hiring stuff, right? Cash sales of used cars, running personal expenses through the business, which is common for many small business owners. I'm not saying it's right or wrong. I'm just saying it's common that sometimes personal expenses get run through the business. But if you're going through a separation and divorce, you've got $100,000 in personal expenses. We need to add that back into your income, gross it up for purposes of calculating support, or you're receiving cash. This is an asset base that you have, and we need to account for it. So in that particular case, the question was, how do we find it, right? How do we deal with this stuff, right? That's the question we started with 10 minutes ago. We brought in a certified business valuator. My client gave a list of all the cash transactions that she could recall during the course of the marriage, and a list of all the expenses personal that were being run through the business. And the valuator got the business ledger and went through them one by one and looked at the source documents. And it turned out about 75% of what my client was saying was correct. The rest was legitimate business expenses. So this did two things. This enabled us to trace and track and recover or account for cash and these expenses. But more importantly for me, it built up credibility for my client, right? She was gaining trust in the process. She met with the business valuator. It's not her spouse was giving the information through her lawyer and nobody trusted anything. They were looking at the book. So this is a process I'm offering to you that worked for one of my clients before. Your concerns are looked at by a neutral party. They provide a report to, that was a collaborative setting, the collaborative team, and saying, okay, here's what I recommend we deal with in terms of an asset-based for cash that's not part of the equalization, and also in terms of ongoing expenses that we can add back to the support payer's income for purposes of child and spousal support. Great question though, Shanza.
Yeah, so I also saw some other question come in about the matrimonial home and assets from overseas or out of province. In short, I recommend listing all assets, all debts. It doesn't matter if it's in Ontario or not. List them, be transparent with everything. When it comes to more questions of the matrimonial home, if the spouse doesn't live there anymore, how do the bills get divided? What happens if one spouse wants to buy the other of the matrimonial home? These are all amazing questions. We actually, next week, we will be doing a deep dive on the matrimonial home.
The one I love is he or she cheated on me, so I get the home, right? Like there should be a consequence to this. Like I'm upset. I want retribution. We get a lot. You'd be surprised.
Oh yeah, we do. And it's hard because Ontario's a no-fault divorce system, right? So whether there was adultery, it doesn't play into the division of property aspect, but all the matrimonial home questions, I'm sorry if we didn't get to you today in detail, but next week we are doing a full webinar, a full topic on just the matrimonial home. So if we didn't answer your question today, please register for next week and hopefully we'll be able to get to it then.
All right. Thank you so much, everyone. Thank you, Steph, Joe, Russ, for an amazing session today. And thank you for going after hours overtime to answer some of the questions. And we will see all of you, hopefully. That's an amazing idea. All right. Thank you, everyone, for coming in today. And we hope to see you all next week. Bye-bye.
Have a great night.
Thank you.
Everybody will see you at the debrief next week. Take care.